Good evening, everyone. Welcome, welcome, welcome. We're going to give just a few seconds to allow some people to go ahead and get logged in, and then we are going to get started. Welcome on, welcome, welcome, welcome. Hoping everyone is having an amazing day on this wonderful Wednesday. All right, so let's go ahead and jump into it. I am Christian McCray Stewart, the founding attorney of McCray Stewart and Associates, your trusted advocates for justice and peace of mind. And we are back again for another Wise Counsel Wednesday. It is truly a blessing for us to be able to come and have these live Q&As to answer the questions of our current, past, and future clients to help you kind of navigate the legal waters, right? And know what decisions you need to make as you are moving forward. And so with that, our topic for today is first-time offender. Here's what you need to know to protect your future. Now, as we are preparing for this live, as everybody is joining in, go ahead and go ahead and share. Send a message to some people and say, hey, they're live. If you have some questions, come so you can get your questions answered. And so I'm gonna give about 30 seconds for everybody to share. And as I'm asking you all to share, I'm going to do the same thing so that nobody misses out on this opportunity. Because what do we say? Sharing is caring, right? So let us take a few seconds and let us go ahead and just share the live, like the live. You can send a text message to some people and say, hey, we're going live. We're live on Facebook, IG as well. And we're also live on LinkedIn. And once we get the sharing done, we're going to jump into it. All right. And if you aren't already following us on our social media platforms, you see the banner that's going across at the bottom. Follow us on IG, follow us on Facebook, LinkedIn. Also, go to our YouTube, McCray Stewart and Associates, and make sure you subscribe because we're always finding ways to put out information so that we can keep our audience, keep the community involved, empowered. Yes, I love it. I love it. As in the chat is stated, educate, empower, and unify, right? People perish for a lack of knowledge. We want to bring you the knowledge. We want to bring you the insight. All right. Without further delay. So our topic for today, as previously stated, is first-time offender. Here's what you need to know to protect your future. We've encountered a lot of people their first time being charged with something and they don't know what to do, right? They're trying to navigate it. They're trying to make sure that they do the right thing. They're trying to ensure that they're going to have a productive future, right? Whatever they had planned, whatever their vision and dreams are, that those things aren't derailed because of a criminal offense. And for the most part, when you're charged with something, it's not the end all be all, right? But having the necessary knowledge and information and insight is going to help you be able to navigate that, right? So what we're going to do is we're going to go ahead and jump into it. I have questions that have already been submitted. We're getting ready to jump into our live Q&A. you are welcome and encouraged to place your questions inside of the chat. Place those questions inside of the chat. And I used to hear this in college all the time, and there's no such thing as a dumb question. If you have a question, ask it. There's probably some other people who are on the live or who's going to come back and watch the replay, and they have that same question, and they may just not want to ask it. So pose the question, ask it, and then, hey, we're going to give you the answer. And let me say this too. We are providing general guidance and insight. My answering these questions does not perform or does not constitute attorney-client agreement or attorney-client relationship. We're just providing some general guidance and insight. Of course, if you get to a point and there is additional information that you need, feel free to reach out to us. I will provide all of our contact information later on in the live. Also, if you're following us on any other social media platforms, you have all the information needed to contact us. All right. Okay, so the first question that I want us to jump into, it says, what will I go to jail if this is my first offense? So, and typically people, when they ask this question, they're not talking about, okay, I've been arrested for something, I've been to jail, I posted bond, right? They're saying, look, this is my first offense. Am I looking at far as the punishment, far as when it comes down to the resolution of my case? And let me add, should they be able to prove it? Should they have a solid case against you? Because that's going to be the first thing that is being explored anyway. But far as a resolution, am I going to go to jail? Unless you are dealing with extreme offenses. And what do I mean extreme? We're talking about robbery, murder, homicide, things of those nature. Typically, you do not see individuals going to jail for being first-time offenders. And this is whether you have a misdemeanor or a felony. There are multiple ways to resolve cases. And with that being said, the fact that this is your first time being in trouble, that is something that is strongly looked upon that your attorney is able to utilize to advocate on your behalf, to advocate for a sentence that does not involve jail time, right? Now, understand, like I say, it is not black and white. It is not to say, cases are evaluated on a case-by-case basis. But in my over 13 years of doing this, first offenders, as I stated, unless it is something very serious, you are not looking at jail time on those offenses. And it's a great question. I'll tell you, for example, we have a case currently that we're dealing with. Young gentleman charged with a DWI, first time being in trouble, and that was his main concern. He was like, look, Attorney Stewart, I just don't want to go to jail. And I was like, look, of course, all attorneys should be careful. I'm not going to make you promises or guarantees. But the thing about it is that I've been doing this for a good amount of time that I can tell you with high probability what we're possibly looking at, what the outcomes will be, what we possibly can get and what we can't get, right? And it's not a guarantee, it's not a promise, but it's just years of experience to be able to prepare you, to equip you, and to also calm those nerves. I understand that when people face these situations and they're like, look, I've never had to deal with this before. I don't know what this looks like. I'm concerned for my future. I'm concerned for my well-being. I'm concerned because, look, I have a job. I can't be off work going off to do somebody's, jail time, things of that nature. Totally understand. But that's why we're here to assist you and to help you to navigate it, to help you navigate the unknown. Oh, this is a good question here. Should I plead guilty just to get it over with? No. simple answer. No. But let me break it down. So I recently had a consult with a gentleman, and he's charged with an offense. And of course, he's going to have a court date coming up soon. And I'm telling him, like, look, this is what happens when you go in there, whether you're hiring me or if you're going to go in there initially on your own before you hire me, you go in there and you plead not guilty. And this is even for individuals, if you think at some point in time that you're going to be trying to work out a resolution to your case, that you're going to agree to some type of negotiation, your initial appearance, your arraignment, that is not going to be the place where you're going to do that. When you first show up in court, what you're telling them is, I plead not guilty. Why is that? because you want to get the evidence. You want to get everything that is relevant to your case. Just because you are charged with something does not mean that you are guilty of that offense. I tell people, we'll initially have these conversations and it's just like, hey, this is what I'm charged with. This is what's going on. This is kind of what led up to it. And I tell them the first thing that you have to do is get your discovery. You have to make sure that your rights were violated. You have to make sure that evidence was obtained the right way. You have to make sure, because the state is ultimately going to have the burden of proving that you are guilty beyond a reasonable doubt, right? And you just want to ensure that your rights are protected. And so you don't just go in there and plead guilty. You want to have everything evaluated from beginning to end. And with that, you're educated about the pros and the cons. This is what it looks like. They have a strong case. They have a weak case. These are the things that work in your favor. These are the things that don't work in your favor. And based off this, okay, you want to potentially go into negotiations or you want to go to trial. But the thing is, just because you've been charged with something, no, you're not going to automatically go in there and plead guilty. And also understanding too that sometimes these cases, they can take time. But even with that, patience truly is a virtue, right? Patience is a virtue. I know some people are just like, look, I just want to get it over with. I just want to be done with it. I mean, there's cases that I've watched over the past several months, and various circumstances, people just get tired and they're like, look, I think this is what's in my best interest. And I just want to plead guilty. But also just make sure that you are consulting with your attorney, right? Someone who truly cares about you, your interests, your well-being, and that who's going to give you that advice to help you navigate it. Just pleading guilty is not the answer. What should I expect during the legal process? Great question. So I met with a client today, had court today, long day in court today, but it was beneficial. But I had a client who was arrested about 6 months ago. And so we're in court today and he's like, what's going on with their case? And I'm like, well, your case isn't filed. One thing specifically for as Texas is concerned, once you're charged with something, that case file is then sent over to the district attorney's office and they're evaluating the case to determine whether or not they're actually going to move forward with the charges. So in this situation, I told him, I was like, your case hasn't been filed. And of course, the next question is like, oh, so is it going to just be dismissed because it's been 6 months? Well, unfortunately, no, it's not going to be dismissed because there's a statute of limitations. They have 2 years to bring these charges against you. Now, is it necessarily going to take 2 years for them to file it? No, but they have up until that 2-year period. So once your case is actually filed, what happens is then we file discovery motions, right? And we're telling the state, look, everything that you have against my client that you are going to utilize to try to prove their guilt, we need you to provide that information to us. So that way we can do our own investigation. We can review it. We can analyze it. That way we're in a position to be able to counsel you and advise you in regards to kind of what it may look like. Then from there, if we're going to have negotiations, we'll have negotiations. Some cases we get to the point, we get discovery, we review it. And even before then, we've had conversations with our clients and they're like, look, I don't care what they have. I don't care what is said. This didn't happen. I want a trial. And that's what we'll do. We go to trial. And we had a situation like that earlier part of last year. A gentleman was charged with domestic violence, assault. And he told me early on, he was like, look, I didn't do this. I'm not going to accept anything. I don't want to negotiate. And we set the matter for trial. And great results. We went to trial and we got a not guilty. But when I say that, what I want people to understand, especially for individuals who've never done this before, the ultimate decision far as whether you're going to negotiate and accept an offer or if you're going to go to trial is your decision to make. It is not up to the attorney. Now, is your attorney required to advise you, to give you advice, to provide you with their legal opinion? Definitely. You can accept it or you can reject it, right? I've had cases where I provided people legal advice, and sometimes you can advise people and they may not like the advice that you give them, and they can decide whether or not they want to accept it or reject it. Totally their decision. But whatever decision that is made, your attorney is supposed to be walking hand in hand with you. So that's kind of what the legal process looks like, right? Sometimes it does not go as fast as people want it to, but that's the process. These charges are brought. If you're in jail, in custody, you're getting a bond, you're bonding out. The case is going to be filed potentially. If it's filed, discovery, conversations, conferences, potential negotiations. If you can't work out something, you're going to trial. And then at trial, hey, what decision is going to be made? What findings would the jury make? And then from there, should there be appeals? That's something that's on the back end. What should I be doing while we prepare for my case if it was a DWI or family violence type situation? Wonderful question. So first I'll address the DWI. It is always important when you're consulting with your attorney and they're asking you specific questions to be honest, to be forthcoming, right? Because in some situations, when you're looking at it, it may help as far as like DWI classes, for DWI charge, to take some of the classes and things that may be required as a part of probation or some type of negotiation. Because when you do those things up front, it's helped us negotiate better terms for our clients, right? When we know that it's not going to be favorable for us, or our clients have expressed like, look, this is what I recall. This is what happened. I don't want to go to trial on this. I just want to ensure that I'm put in a position to potentially have the case dismissed or be able to get this record sealed. There's different things that we can look into, but kind of taking those classes ahead of time. And that'll be information that your attorney can provide to you to say, look, you need to take this class, that class. These are the things you need to be doing. Another thing that some people run into if you have a DWI that's greater than 0.15 is that you might have interlock requirements. What does that mean? That an interlock device has to be placed on your vehicle. If you don't have a vehicle, then you have to have a handheld device. I've seen that. I have yet to encounter that in Mississippi, but definitely I see it often in Texas. And so with that, comply with the requirements when they're telling you to blow. If you get locked out, do what's needed to get back in an active status, a good status. Because what people don't understand or realize is that if you violate the terms of your condition, as far as your bond is concerned, guess what? The judge can order you to be held in jail. Nobody wants to sit in jail. And your attorney definitely doesn't want you there either. Regardless of what my clients are charged with, our ultimate goal is to always get them out, because it's going to be better for us to represent you and serve you and for you to help us with your case if you're out rather than in. When it comes to family violence situations, I have a lot of these cases, and I go and I ask my client, are you and the complaining witness still communicating, things of that nature? Yes. The answer should be no. I've seen many of these cases where sometimes, and this may not necessarily be the case in everybody's situation, but I've seen a lot of cases where an individual was upset, and rather than finding better ways to navigate a situation, they utilize the court system as a way of revenge and control. I had a case with it, and even as I think about it, this is the first one that comes to mind. I had a young man who was continuing to communicate with the person who had made these allegations against him. And then it didn't stop. It started with one set of allegations, came down to another set of allegations, which now you're dealing with 2 assaults. You're also dealing with a violation of your bond conditions, because typically when you're charged with any type of domestic violence, family violence type of assaults, those situations, your conditions is going to say to stay away from the victim, right? To stay away from the victim, quote unquote. Stay away from that person. Don't communicate with that person. Now, do some people do it and it works out? Yes, it does. But as your attorney, what am I going to tell you? I'm going to tell you to comply with your conditions. I'm going to tell you to do what's necessary to ensure that you don't find yourself with additional charges and things of that nature coming up. Just to be mindful. To be mindful about the decisions and things of that nature, because I see people, it happens to them, and then they're facing additional charges and additional charges. And the thing about it, one thing far as in Texas, what happens is if you're dealing with multiple charges in regards to like family violence or violations of bond orders, after so many, guess what? They're going to trump it up. It's going to move from a misdemeanor to a felony. And you just don't want to be in that situation. So DWI, you're kind of taking necessary classes and things of that nature ahead of time. Family violence situations, stay away. Even if the person is saying, hey, look, I don't want to pursue the charges against you, provide that information to your attorney and let your attorney communicate with that individual to get what's necessary to deal with that. Wonderful question. Let's see. The next question that we have. Let's see here. Okay, we have, what is the difference between a felony and a misdemeanor? So basically, what you have, the difference between felony and misdemeanors is the statutory penalties, right? And when I say statutory penalties, is basically what the law is saying you could be punished for if you have that particular charge. So let's say you're dealing with a Class C assault, which is kind of like a traffic ticket, right? That's a fine. The most you can get for that is a $500 fine, as far as Texas is concerned. If you're in Texas and you have a Class B misdemeanor, this could be a simple DWI, right? It's not over 0.15. There's no accident involved. They're going to classify it as a Class B misdemeanor. There you're looking at 180 days or a fine not more than $2,000. If you're dealing with a Class A, which could be a DWI that's 0.15 or greater, you're dealing with a penalty of not more than a year in jail or a fine not more than $4,000, right? Then when you get into felonies, it changes. You have state jail felonies, right? Where you're looking at doing jail time. You have third degree felonies, second degree felonies, first degree felonies. And so what happens is when you're talking about misdemeanor and felonies, it's basically how they've kind of classified it in regards to like the severity of the offense and the amount of time that you are exposed to, right? Not the amount of time that you're going to get, but the amount of time that you are exposed to. So that is the difference between misdemeanors and felonies. It's just the severity of it. It's basically what potential sentence could be imposed if an individual should find themselves being convicted of those charges. Are there things that I should avoid doing or saying during this process? Yes, anytime that you are charged with anything, I will tell you, do not communicate or be talking to individuals, especially law enforcement, right? I know we done some a Wise Wednesday about that, about your rights and what you have, your right against self-incrimination and not to speak if you're being pulled over. You want to be careful about individuals you speak to. Why? Because the only conversations that are protected are the conversations with your attorney. You have protection, with doctors for certain things, but typically you don't see those being the issues, right? With your attorney, there is attorney-client privilege. The communications that you have amongst each other are protected conversations. But say you're just talking to a friend and you're just like, yeah, I was charged with this and this is what happened, X, Y, and Z. Should the state or someone representing the state become aware of those conversations, well, guess what? You potentially made statements against your interest and they could subpoena that person to discuss those conversations, right? You typically don't see these in misdemeanor cases, small felony cases. These are kind of when you get up into some of the bigger type of cases, but it's still one of those things to be mindful. Just don't communicate and do not. One of the things that is troubling to me, especially for my younger clients, my clients who are 18, 19, early 20s, is that they'll pick up an offense and I'm like, look, we're going to get you out of this. I don't want to see you back in this system. I don't want to see you back in this courthouse. And then I get notifications or it comes to my attention that they have picked up new charges. It does, as a first offender, it does not benefit you in any shape, form, or fashion to continue to pick up charges, to continue to be in trouble. I mean, to the young generation, I tell them, I talk to these young kids as though they were, my niece or my nephews. Look, that you don't want to be tied up in the system. Steer clear. If you made a mistake and you found yourself in trouble, okay, it's not the end all be all. We can work through this and get you back in the place that you need to. But what doesn't help is if you continue to get in trouble. Continue to get in trouble. You have to steer clear. So if you're in company that doesn't mean you well, get out of it. And we have to be communicating this and sharing this with the younger generation. Do people make mistakes? Sometimes are you in the wrong place at the wrong time? Yes, things like that happen. But at some point, what happens is it's going to be hard for an attorney to advocate and say, well, now my client he started with one charge. Now he has 3 charges. All of those were a mistake. Or all of you have to be smart about it. And the thing about it is, look, don't continuously find yourself being wrapped up in the court system where then other people are being able to begin to start making some decisions that's going to impact your life and your future. I've seen that recently on two cases, and it's just one of those things. It's just like it doesn't have to be this way. We have to be educated, but this is too the reason why we're doing this as well. Empowerment. If you know young people, right? They're always on social media. Share with them when we go live so that they can come and they can join and that they can be educated, right? Because a lot of them don't know. And I've encountered 2 young clients who should be in the midst of finishing up high school, and now they're dealing with court cases, multiple court cases. And that shouldn't be the case. They should be focusing on their futures. Are there certain factors that could affect the outcome of a case? Yes, definitely. Let me give an example. Let me utilize assault family violence cases, right? Because I deal with a lot of these. Some cases I see, it's kind of that what I describe, retaliation, vengeful. I know that if I make this call, they're going to be on my side type of thing, right? You've made me upset and I'm going to use this as recourse. And allegations are unfounded, but an individual has been charged. In those situations, you're basically, it's a stronger position there to get those cases dismissed, right? And I've seen cases where you have an assault family violence, and I can have a client who comes and tells me, I didn't do X, Y, and Z. But then I review discovery, and it's like, unless you have a person who is kind of, and not that this hasn't happened, but unless you have a person who is really not all there mentally, harming themselves, we have a lot to overcome. And in those situations, the severity of the outcome may be different. Not per se that they're necessarily going to jail, but one thing that you will find here in Texas is findings of assault family violence, right? You can resolve these cases without that finding, which is always the ideal resolution, right? Sometimes that's not the resolution that you're going to get in negotiations or even at a trial, right? And with that, because in Texas, if you have an assault family violence finding, you cannot possess a firearm ever again, right? Also, should you pick up additional charges along the same lines, you're looking at that being the charge itself being made more severe. So there are various factors. Also, too, as we're even discussing, when I talk about young people, your age is a factor. I've had young people, I've had some older people who the first time ever get in trouble, and they're older and they're like, look, I've never been in trouble a day before in my life, right? Also, the type of charge that you have, that is going to play a part as well in regards to the resolution of your cases. And we're focusing on first offender, so I won't discuss about, if you have prior charges, that's a factor, but it's not related to, I guess, the point of our discussion for today. But yes, also too, this is something that DAs look at when it comes down to negotiations. How a person is responding or interacting with law enforcement during the time of the arrest, right? If you have people who are out there being belligerent, they're being aggressive, combative. It does not help in negotiations, because at the end of the day, from my point of view as an attorney, what I'm always trying to do is go in there and show or speak about my client as a person, not just the charges themselves, but overall what my client has going on. Hey, I've gotten some amazing outcomes for clients because I say, look, my client was so cooperative. They were cooperative. They complied with the officer's instructions and directions. They didn't give them a hard time. And trust me, those things, they may seem small, but it's huge, and it can have a significant impact on your case. That's why I tell people, I think this was a couple lives ago, you do not defend your case on the side of the road. You allow that to take place inside of the courthouse. So as a defendant, what are my legal rights? Yes. So initially, when you're first being encountered, right, you have a right to remain silent. But a lot of the rights, and this is what we typically go over and inform individuals of, especially when they're getting to a place to say, hey, look, I think I want to make some type of deal, right? So you have a right to a jury trial. You do not have to accept any plea offers that's been extended to you. You don't have to negotiate any of that. You have a right to a jury trial. You have a right to present witnesses on your behalf. You have a right to cross-examine any witnesses that the state brings on their behalf to try, to bring evidence against you. You have a right to testify or not testify. That's one of those decisions that you ultimately make. Hopefully you're doing that in consultation with your attorney to determine what's going to be best for you in regards to the strategies that you all have, should you all decide to go to trial. And that's, like I say, and that's one that you hold. You have the right to present evidence on your own behalf, right? There may be an incident where, say, you have eyewitnesses to an event or circumstance that took place. Well, your attorney can bring that person into trial and have them to testify on your behalf, right? If you go to trial and it doesn't go favorable for you, and you feel as though the judges made some errors in regards to evidence, or some things were taking place in the trial that were against your constitutional rights, well, you have a right to appeal. So these are the rights that are allotted to you as a defendant, right? As someone who's been charged with an offense. Understanding, if you decide to actually plead, then those rights, you waive them. Okay. And one huge one is you have a right to all the evidence that the state has against you. Now, I would say there's changes in laws and things that's been pushed to, I won't say eliminate that, but we just, we have different acts and different things that has definitely helped us along the way to have more evidence and be better equipped to defend our clients. But that's right that you have. You have a right to see everything that they have against you. Hey, Harriet, thank you so much for joining in. Thank you. So yes, a great question. So that's like a brief summary of the rights that you all have, or that we all have. One question. Oh, if someone writes a book and uses names about something that actually happened, is there liability for telling the truth? Can someone sue you for slander? Now, with that, so people can sue people for anything, right? A person can take you into court and they can sue you for anything. But the thing about it is they have to prove that it's slander. They have to prove that, it's untruthful, right? But if you are telling the truth, that's a problem. That's when you get to like defamation, libel, and as you mentioned, slander there. But if you're telling the truth about something, can they sue you? Yes, they can. But being able to prove their case, that's going to be the issue. That's going to be the issue. So we had another question. Do I really need a lawyer if it's my first defense? You have some people. So one thing about it is, majority of the states, you can definitely do pro se if you want to represent yourself. I personally don't recommend it because I've seen people hinder themselves or not get the best outcomes because it's just a lot of things that they do not know. You have people who even decide to do trials on their own. Like, I'll represent myself. I don't need an attorney. It's not advisable. Now, if somebody's simply dealing with a traffic ticket, I have people who will call me and say, hey, look, I had this traffic ticket. I have this going on X, Y, and Z. And I'm like, let me give you the insight. Let me tell you what you need to do, what you need to request, right? Because in that situation, you're probably going to be in a better position to go ahead and do this than come and pay me to do it, right? But I say first and foremost, consult with someone. Consult with someone before you just make the decision to say, look, I'm going to jump out there and I'm just going to do this on my own. Make sure that you take that opportunity to have the conversation so that way you know what you're doing. If you decide that you're going to try to do it pro se and you're not going to hire an attorney to represent you. Oh, you're most welcome. Most welcome. And also, too, there's a link that was just placed in the chat. If you want to go back and look at previous lives that we've done, you can go back and check out those titles and say, hey, this is something that I'm really dealing with right now. Let me go and see if I can get some insights from various questions that people have presented to us. You can find that link was placed in the chat. How will a first offense impact my job or future opportunities? This is one of those questions where, as an attorney, and understand, like it says, that you are innocent unless or until proven guilty, right? And however, with that being said, there are people who they've been charged with misdemeanor offenses, felony offenses. And then you see even just the charge itself, when it shows up on their background check, that it's hindering them for employment. It's hindering them. Oh, one thing that I will tell you, as far as like the family, the assault family violence, I've seen people, it has impacted their ability to be able to rent from different places. And so I'm not going to say just across the board that like you're going to be denied employment or housing, but it does have a negative impact. Many people, they're going there applying for jobs, and people are seeing that these charges are on there, even though they're pending charges, right? They haven't been found guilty of anything. They're negatively impacting their lives. So always steer clear, right? To the extent you can. Most times I see people are sometimes with the wrong crowd, hanging around the wrong people, or as we talk about the assault family violence, you just have someone who may want to use the system in a negative way, but these factors is hindering people and it's hurting them. But the thing about it, when you have good counsel who's representing you, hopefully they're working to put you in a place to where eventually that record is going to be expunged or it's going to be sealed. And then that way you don't have this continuing ongoing dark cloud that's kind of hanging over you, if you will, when it comes down to like employment or your living situation. Can factors such as your appearance, clothing, tattoos, and similar aspects impact my case? I will say yes, they should not, but I will say yes. And this is what I mean. So, we recently just solved the case, and you had a gentleman, a lot of tattoos and things of that nature, and you'll have different departments and different agencies, right? They're evaluating things, and they had this individual labeled as being a part of a gang. Is that true? Could they prove it? No. But when it came down to us negotiating and different things we were asking for, that was something that came up. Oh, well, we have our gang unit who has called and inquired about this case because they think this individual was in a gang. And then my initial question is going to be, well, can they prove it? And is this case related to any gang activity? If not, then why are we talking about it, right? But so things of that nature can impact your case. Also, appearance, when you are showing up in trial. I have many cases where clients show up and it's like, okay, we had a discussion about what you should wear. No shorts if you're going before the judge. No flip-flops if you're going before the judge. No spaghetti striped shirts if you're going before the judge. First impressions are everything. And the thing about it is that most judges don't get involved when it comes down to your plea negotiations and things of that nature. But sometimes judges are able to make adjustments to your plea. Sometimes they don't even have to accept it. But I'm going to stick on the positive side, right? I had a young lady, she was going before the judge, and they were trying to give her, 6 months. The judge is looking at everything. Of course, my client is there. She's dressed as I told her to, casual, professional. She's answering all the judge's questions, being respectful. And just like, you want to know something? Tell me a little bit about what's going on. Okay. I'm reducing this from 6 months to 4 months. We all are innately, we function from our senses, right? Based on what you see, it begins to formulate some type of ideal opinions and things of that nature in your mind. So trust that that happens when we are working on your cases from your attorney's standpoint. The thing is, whether it's the prosecutors, the judges, whoever, we're all people, right? And so some of the natural tendencies that you have, understand that they're going to have those natural tendencies as well. And like I say, now that doesn't mean, I know personally, I'm not going to allow prosecutors to use things of that nature negatively against my client. And when those things come up, I am going to actively advocate for them. But we have to be mindful of those things. So that is a wonderful question. And like I say, when it comes down to the appearance, it's just you're making a first impression. You want to make the best one, right? Tattoos, those are something that typically you can clear up. Like I say, the only time I've seen them really become an issue if it appears as though they're tattoos that's like gang related, things of that nature. But just the general tattoos, or you have a tattoo here or there. We've just gotten to a place maybe some years ago that probably was more of a thing where it was looked upon or frowned upon, should I say. But now, I mean, you have prosecutors who have tattoos. You have the defense attorneys who have tattoos. Some of the judges may have tattoos. You may not see them visibly because they're up there with their black robes on, but to the point that just simply having them in and of itself is negatively impacting your case, not so much. Great questions. And look, yes, continue. I mean, as you have those questions, we do have a few more minutes left. Continue to place those in the chat. How long would the legal process take for a first-time offender? I think I kind of mentioned this briefly when I was discussing another one of the questions about just the process and what it looks like. From start to finish, it really depends on that intake process, right? They have so long to actually bring official charges against you. And that's the thing. If I can give, I've had some cases now where we've been able to resolve them fairly quickly, right? Person was actually charged earlier this year. We'll have this case resolved by the end of May, right? It's going to result in a dismissal. I've had other cases where, for various reasons, the case wasn't filed until close to the statute of limitations, right? So say I have a case in 22 that's not filed until late 24, like close to the deadline for them to file it. Well, then, we have an additional 6 months. So in that process, it's taken a little longer for that individual simply because the case hadn't been filed. So it varies. It really does vary. Some can be resolved fairly quickly, and some there is delay for various reasons. And most of the times that is out of the control of your defense attorney. I try to let people know that, right? To the extent that we can control any aspect of those things, we're going to go as quickly as possible, of course, in alignment with our strategy and what we're trying to do, right? But we'll do everything that we can to get the case pushed along as fast as possible in communications with our client and, just how we're trying to navigate and deal with the case overall. Will this show up on my background? This is a great question. I get it many, many times. And I did touch this briefly, but yes, once you are charged and you go down there and they fingerprint you, typically individuals will be able to, employers, housing agencies, listing agents, they'll be able to pull up to do a background check and it pull up. Now, have I had clients to say, hey, they were doing this background check and nothing's showing up? Hey, that's a good thing, right? But that's not necessarily the norm. If you've been arrested and you've been fingerprinted, you've been booked, you've been charged with something officially, typically, if anyone runs a background check on you, it is going to show up. It's not going to show that you were convicted of anything. It's going to show that you do have a pending charge, however. And then with this, let me go ahead and just kind of in the same lane, is you get to a place that the case has been dismissed, right? Your attorney works it out, you get a dismissal on this case. Then it'll still show up and it'll show that it's been dismissed. When you're in a situation where your case has been dismissed and you qualify for an expunction or a non-disclosure, it is going to show up until you get the necessary filings done with the court. Oh, that's a perfect question. Right in line in the chat, it asks, can it be removed? Yes. So if it's dismissed, it can be removed from your record. Now, let me touch on this a little bit, and we'll do another live to dive more into this, what it looks like. But so in expunction, you have those for outright dismissals. I mean, whether you do a conditional dismissal, no probation was related to it. They just dismissed it, right? In that situation, you're going to qualify for an expunction after the statute of limitations has passed, unless you're in some type of program that allows for an immediate expunction. Alternatively, what we also see a lot is if people are doing deferred adjudication. And what that is that you offer the plea to the court and they're like, look, I'm going to hold on to it. I'm not going to find you guilty. If you do everything successfully, I'm going to dismiss it. In that situation, what you're going to qualify for is a non-disclosure, right? And with a non-disclosure, it allows you to seal the record. And when you're sealing it, most people aren't going to be able to access that record besides like state and federal agencies, law enforcement agencies, potential licensing boards for the state or federal government agencies. But when you're dealing with, we said like some people are having issues with employment and housing, typically those entities will not have access to those records. What are the chances my charges will be dropped or reduced? It depends. It truly depends on the nature of the case. It depends on the evidence that they have. Is it a weak case? Is it a strong case? I've seen cases where they're weak and initially they may not want to dismiss it. And so we're like, okay, set it for trial. And before a trial happens, the case is dismissed. But let me say this, and this goes back to the assault family violence cases. So many calls. It's like, well, my girlfriend, my boyfriend called and made these charges against me. Now they want to drop them. I wish it was that easy, but it's not. So just because an individual makes the allegations, then says, hey, I want to drop them, it does not mean that the state has to drop the case. Is that something that we as your defense attorney, I'm going to utilize? I am. But it doesn't mean that the state is just going to say, okay, outright dismiss it. There are cases where the state will bring forth a case to trial without the complaining witness if there's additional evidence that they believe that they're going to be able to get into evidence. This is why I try to tell people, look, if it's a situation where you all are just in the heat of the moment, having one of those arguments, separate. One person leave and go somewhere, the other person do separate. Do not use law enforcement, do not use the court system as a mediator to your problems or your confrontation. It's not, because it's not one of those situations where you wake up the next day, you want to know something, I'm not mad anymore, let me go back down here and drop these charges. It doesn't work that way. It doesn't work that way. And so people need to know that and be mindful of it. I have so many calls and they're just like, yeah, this person wants to do an affidavit of non-prosecution. I was like, oh, we're going to get that, and it's going to help us. But it doesn't make the charges just vanish, right? And I say that, and also too, I would put this caveat out there that from the government's perspective or the state's perspective, I can understand it. I mean, you have instances where people didn't feel comfortable coming forth, right? And they don't want to have a situation where they dismiss a charge and then you come back later and something more severe has happened, right? And I would say from my experience, that's not necessarily the norm or what's always happening, but it's one of those things. Look, if you're just upset, you all are just having an argument and you just at, edge. And sometimes too, it's just, look, maybe you had too much to drink. Separate, go your separate ways, cool off, and then come back, right? Is there a statute of limitations on being charged? Yes, there is. There is a statute of limitation. For most misdemeanors, it is a 2-year statute of limitation. Recently, we had a change in the law when it came down to assault family violence cases. I want to say it's now 3-year statute of limitation. For various felonies, you may have 3-year to 5-year statute of limitations. For like murders, things of that nature, is no statute of limitations. But yes, they do. There is a statute of limitations that they have as far as the time frame to bring those charges. And basically what that means too, legalese, right? So what that means is that, so say for instance, you were charged with a DWI in January 1st, 2023. Well, they had until January 1st of 2025 to bring that charge against you. And if they fail to do so, then they can't bring it. And if they try to, then of course your attorney is going to argue that they're outside the statute of limitations. So that's what that means as well. So you're having the statute of limitations when it comes down, it's in play when it comes down to officially being charged. And also when you're able to qualify for certain expunctions when it comes down to dismissals. Okay. Can I travel or move if I'm facing charges? Yes. Unless for some reason you have a bond condition that says you cannot travel outside of the county or outside of the state, you can travel. Typically, you just want to make sure that you're doing what's required to stay in communications with your bond company. You want to make sure that when you have a court date that you're appearing, but typically there's no restriction on your ability to be able to travel if you're out on bond while your case is pending. Okay, and I think I've covered all the questions that were previously sent in. I don't currently see any new questions in the chat. So what I will say, as always, just to let you all, for those who may have joined on a little late, I'm Christian McCray Stewart. I'm the founding attorney of McCray Stewart and Associates. We are your trusted advocates for justice and peace of mind. We do these Wise Counsel Wednesdays to come and provide the community with information and knowledge so that they're equipped to navigate whatever legal encounter that they have. So every Wednesday, we're going to have various topics. We're asking that you share this with those that you know. They can come and ask, they can come and ask those questions. And to the extent that we can provide some general advice and guidance, we're happy to do so. If you haven't already followed us on our social media platforms, follow us. We're on Facebook, we're on IG, we're on LinkedIn. Also, you can go to our YouTube page and subscribe. If you haven't signed up for our newsletter, we send out a newsletter every month. And it's just useful tips and information that we think will benefit individuals. A link will be placed in the chat. You can sign up for the newsletter so that you get that information. You don't miss out on anything. You can always reach out to us if you have a more in-depth situation that you need to discuss and need some legal assistance or guidance with. We love what we do. We love to help people. It's truly our passion. And so, as we always tell people, we're here for you. And we're concerned about the overall person. It's beyond more than just your legal situation, right? Is that important? Yes, it is. And we truly understand that. But we want to make sure that not only do we address the legal problem, we want to make sure that you have somebody who you know is going to come alongside you, truly care about what's going on and do what's in your best interest, right? Let us advocate for you. Don't go out there and try to stress and do it alone. So, if you want to, you can scan this QR code, and to get more information, our website is on there, all the contact information. Feel free to reach out to us by any means. Social media, you can DM us, contact us form on our website. Reach out to us, give us a call. We're here for you. It's truly our pleasure. Yes. Oh, it is truly a pleasure. And it's only going to get better. And we have a lot of new things that we're going to be trying to do, showing up in the community. Of course, when the time comes for that, we will make the necessary announcements. But we ask you all engage and share with us. Even beforehand, you can share with us topics and areas of the law that are meaningful for you, that you want to discuss, that you think will help not only you, but help others. Share those with us. Okay, we're not doing this for ourselves, right? We want to know what you all need, what you all have concerns about, so that we can bring that information to you. But as always, we appreciate you all. It's such a pleasure to come here and share this information, to answer these questions. And until next time, you all have joined us on Wise Counsel Wednesday. Good day. Good night, everybody, or good evening.